Testing. Hello, everybody. Good afternoon. Thank you for coming, and I'd like to thank Commissioner Brown and his staff for the invitation. Those last two presentations are going to be hard acts to follow because the presenters told some really compelling stories, and I'm not here to tell a story, but I am here to educate. There's a lot of confusion about intellectual property out there. I'm going to pick on the Billings Gazette a little bit. It was big news in Billings about a week ago that the Zest kitchen store downtown had to rebrand because they received a cease and desist letter. And the headline was, something about kitchen store engages involved in copyright dispute. And, I came home from vacation and just kind of cringed. I get calls all the time from clients who want to patent their name or trademark their invention. I've been in front of a federal judge before who said to me, this was a trademark case, can you explain how it is that folks can trademark a word that's in the dictionary? So, yes, you can, as long as you're not using those words in connection with the goods that they define. I testified before the U.S. Senate Finance Committee, and there was a lot of confusion about the various types of intellectual property among the senators on the panel. So hopefully you'll come away today with a better understanding of the types of intellectual property. And with that, let's start with our overview here. Today we're going to be talking first about the different types of intellectual property. Next, what investors should look for in terms of IP due diligence. So you're a buyer or you're a bank financing a transaction, how target companies can prepare their IP portfolios for acquisition. And then lastly, how AI has changed the IP landscape. So let's start with the 4 buckets of intellectual property: patents, trademarks, copyrights, and trade secrets. According to the US Supreme Court, anything that is made by man under the sun is patentable. Okay, this is US Supreme Court statement pre-AI. I'll be talking about AI at the end of this presentation. You cannot patent things that exist in nature. You go out into a field, you go down to Peru. There was a professor from MSU, went down to Peru, came back with some fungus in the back of his truck. He patented a practical application for that fungus, but you cannot patent the fungus itself. So you can't patent things that exist in nature. You can't patent algorithms themselves. 2 + 2 = 4. That's obviously simplification. But you can patent a practical application of an algorithm. So those would be software-related inventions. Trademarks are anything that functions as a source identifier. So you heard the Folkvords talk about the importance of their brand. I'm really excited for the panel this afternoon. It's going to have Jess Dane and Jim Windjam, both of whom appreciate the value of trademarks and have invested in their portfolios. So a trademark can be a name, a slogan, a logo, and even a sound. Harley-Davidson has registered the vroom vroom, the particular sound of their motorcycles. Montana, to bring it home here, the meth project here in Montana. How many of you have heard that? This is on their advertisements where they have that sort of crinkle sound. Thank you. We have registered that as a trademark. So trademarks are any form of source identifier. Copyrights protect creative works, right? We can think about books, sculptures, paintings, movies, jewelry, lampshades. There are things that might be functional, but that also have aesthetic or ornamental aspects. Those pet toys. Westpaw here in Bozeman has copyright registration. So anything that has some sort of aesthetic or ornamental aspect to it that is original can be registered with the Copyright Office. Important to know about copyright that the underlying idea is not protected, right? So when, let's say, a client calls me who has a consulting business, and they go around the country and do a certain PowerPoint about, live and love richly is one of my clients. So she could register with the Copyright Office her PowerPoint presentations, but her method of coaching is not going to be protected by that copyright registration, okay? Same for software copyright registrations. I'm simplifying here, but you're basically protecting that source code, not the underlying functionality of the software program. Trade secrets are anything that has economic value to a competitor. We'll look at a definition here in a moment. And that you treat as confidential. So Here's a real world example. A company out of Powell, Wyoming, they were a magazine publisher, and you would walk into their office, and on the board, like that artwork back there, they would have their storyboard for the next issue. And they claimed that that was a trade secret, the way they laid it all out. And without breaching confidentiality, we went to trial on that and won every single factual and legal issue. But the arbitrator at the end said, this was something that folks could see when you walked into the office. You weren't treating it as a trade secret. You weren't restricting access. So that's another requirement for something to constitute a trade secret. Do I have any questions so far about the 4 buckets of IP? Okay, terrific. So let's talk about patents. There are actually 3 types of patents. There's utility patents, design patents, plant patents. When most people think of a patent, they're thinking about a utility patent. So we do quite a bit of design patent work, but utility patent is protecting, you have to claim an invention in terms of structure, but you can think of it as protecting the functionality of the invention. A design patent is a lot like copyright, okay? So oftentimes, if a client has blown the disclosure deadline to pursue a design patent, we'll talk about disclosure deadlines in a bit, we might pivot and try to get copyright protection for that very same thing. So there are some overlaps between certainly design patents and copyright. So the term for a utility patent is 20 years from filing. Term for design patent, 15 years from issuance. I'm going to get into the weeds a little bit here. IP rights were written into the US Constitution. Article 1, Section 8 addressed patents and copyrights, didn't address trademarks. And what it said about patents and copyrights, the founding fathers said, we want you to grant inventors and authors protection for their writings and their inventions for limited periods of time, okay, for limited times. Didn't define it. So Congress from time to time will tweak the patent term, tweak the copyright term. Congress can do that as long as it's limited. Trademarks, not in the Constitution, no limited times. Same for trade secrets. Those 2 things can last forever. That's just a digression there. Maintenance fees are paid for utility patents. If you're a small entity, you're going to pay about $3,000 at the, $1,000 at the first renewal, about $2,000 at the next, and $4,000 at the next. Design patents, no maintenance fees. You can go international for both utility and design. Okay, the international treaty for utility patents is called the Patent Cooperation Treaty. The filing deadline is 1 year after the date of your US filing. It covers virtually every country on the planet that you might be interested in seeking patent protection in. And then there's also an international system for design patents called the Hague. Infringement. So, when looking at a patent and trying to decide either whether you infringe or whether someone else infringes, you have to read the claims. So I'll start with design patent because it's pretty easy. With a design patent, I always tell clients there are no words. It's not 100% true, but there are very few words. Design patents are defined by the drawings, and they're narrowly construed. So there's only a single claim in a design patent. It says, I claim an ornamental design for whatever it is, a fence anchor, whatever it is, as shown in the figures. So the test for infringement of a design patent is the ordinary observer test. If you're in front of a jury and you show them this thing that you think infringes, okay, I'll use an example we're working on right now. I have a client that has, I'm going to call it a fence anchor, but it's little clasps. It's cat's claw. Little clasps that are used to secure fence wire to the fence post, right? And so my client has a design patent on his cat's claw. So this is an example of something that has functionality, but it was just a single piece of metal, so very hard to get a utility patent on that. But when the functionality is inherent in the design, as it was for him, we would secure design patent protection for that. So he sends us a lot of links. I'm not divulging any confidential information, but he'll send us links from time to time about other similar things he sees on Amazon that he thinks infringe. So we have to do the analysis. Is this close enough visually? Okay, that's how you determine infringement of a design patent. Utility is written out. Okay, you're going to have a written set of claims. There's a lot of art and schooling to it. Patent law is the only area of law where you have to take and pass a separate bar exam, and you have to have an engineering or science degree even to sit for that exam. So there's a lot of sort of art and science to patent claim drafting, but that comes into play with utility patents. And then invalidity. So a lot of times clients will get cease and desist letters on a patent, and they'll say to me, how could this patent even have issued? There are ways to challenge the validity of a patent. I've used the term prior art there. Prior art is anything that was in public use, published, patented, or offered for sale before your filing date, okay? The United States has been on a first to file, technically it's first inventor to file, because if you're not the inventor, you got the idea from someone else, but you're first to file, that doesn't go. But you have to be first inventor to file. We've been on that system for about 16 years now. But everything that was published, patented, offered for sale, or in public use before your filing date is prior art. Okay, all that stuff will invalidate your patent. If that disclosure, that prior disclosure was your own, and it was within 1 year of your US filing date, that's okay, all right? But that's what prior art is, and invalidity is not a defense to infringement, okay? So I spent a lot of my time counseling clients on, first we do the infringement analysis, let's talk about utility patent, but you know, does your thing fall within the scope of this patent? And then if it does, we segue to invalidity, and we talk about you know, ways to challenge invalidity, but going the invalidity route is not preferred to making a non-infringement argument, because it's more expensive to try to overturn an issued patent. And I'm not going to get political here today, but it is a fact, and I happen to support much, in fact most, in fact possibly all of what this administration is doing at the Patent Office, but they are making it harder to challenge issued patents. Okay, so that means if you get a cease and desist letter now and you don't have a non-infringement argument, you are more likely to settle than you were in the past. So I could give a whole separate presentation on that, but this administration is very pro-patent. As a patent lawyer, I think that's great. Questions so far on patents? Okay. All right, trademarks can be registered on a state or federal level. Patents are federal only. There are advantages, several advantages to a federal trademark registration. Gives you exclusive rights to the mark in all 50 states. Your ownership of that mark becomes incontestable after 5 years as long as you file what's called a Section 15 affidavit. Now, there are a lot of clients who handle their own registrations, and they might get it through. This isn't a sales pitch. I'm plenty busy, but I want you all to succeed. And where I see them falling down is they either don't renew, and so 5 years later they lose their federally registered mark. Now someone else is in line and they can't go back and register their mark. That's a problem. Or they'll file that first renewal, that Section 8 affidavit. They never do the Section 15. That's what renders your ownership incontestable. So that Section 15 affidavit is important. If your mark is registered federally, you can get up to $2 million per infringed mark for willful infringement, and up to $200,000 per mark if it's non-willful. That's a big hammer, right? So we always put that $2 million number in our cease and desist letter when we send them. And then if you have a US trademark application, you can use that as a springboard for a Madrid Protocol filing. The Madrid Protocol is the international trademark treaty the US joined in 2003. And I'm telling you, it saves clients 2/3 of what it would have cost you before to register your mark internationally. It's a single international application. You check the box per country. Thanks for nodding. You check the box per country. You never have to retain foreign counsel unless there's a conflict in a particular country. So huge cost savings there. Also, is there anyone in this room who has heard of UDRP? Anybody know what UDRP is? Okay. UDRP is when, is Jim Winjam here? Is Jim in the room yet? Okay, I'm gonna pick on Jim. We've done a number of UDRPs for Jim and Obos and many Sims and several clients in Bozeman, but UDRP is when someone takes your trademark and they register it as a domain name, right? So I'm gonna do waltdisneymt.com, they're gonna get UDRP'd. So it is, you're not going to court, it's an online web-based arbitration proceeding. And the reason I've listed it here is technically, you can file a UDRP complaint without a federal registration, but you're probably not going to win. Okay, so if a client comes to me and we haven't registered the mark federally, I'm going to tell them to do that first. It takes about a year before we can proceed with that UDRP. And a lot of times, it's not just about the domain. But it's about a copycat website or a phishing website, right? They make it look exactly like yours. They've got credit card, give us your Visa, MasterCard numbers at the bottom. But if they've got your trademark in the domain name, then we can probably get that taken down within a matter of 45, 90 days. It's really quick, okay? A lot of what we do in the law to adjudicate disputes takes a long time, but UDRP is a really great tool if it's available to you. I want to point out there are two different registries federally. There's a principal register, which is what everybody wants. That gives you exclusive rights. Supplemental register would be for a descriptive mark. Okay, so the advantages of supplemental register are that you can still use the registered trademark symbol. I tell clients it serves as a shield but not a sword. Because you don't have exclusive rights, I can't send a cease and desist letter if my descriptive mark is on the supplemental register, but it's going to prevent other people from registering the same or similar mark. And then if you have at least 5 years of use of that descriptive mark in commerce, you can try to get it onto the principal register. And then the International Trademark Treaty is the Madrid Protocol. I think we talked about that. Any questions about trademarks so far? Okay, let's move right along. Copyrights. Now, technically, because I get this question all the time, protection is automatic upon creation. You sit down and write a book or create a film, and you own the copyright to that work. You write a piece of software, as long as you did it yourself and AI didn't, you aren't vibe coding. However, I tell clients it is a right without a remedy, because you cannot sue anyone for copyright infringement without a registration. So that work needs to be registered with the US Copyright Office. There are certain limited instances in which you can do group registration, like a bunch of photos, but it's very limited. So a lot of what we do is work with clients to talk about prioritization, especially if they're prolific creators. Sometimes if a client has a lot of content on their website, we'll register the entire website content and then redo it the next year. Most of what we do in the copyright realm is probably for software, a lot of what we do. And so foreign works are exempt from this registration requirement. So this can trip you up. If you get a cease and desist letter, usually what I do, if my client's on the receiving end, the first thing we say back is, show me your certificate of registration. Because although they own the copyright, I know they can't sue my client, and they're really just saying, pretty please, unless they've registered it. The exception would be if that copyright claimant or the author is from a foreign country. So they are exempt if that work is a foreign work. Just like trademark, there are statutory damages up to $150,000 per act of infringement if it's willful, and then up to $30,000 if it's not willful. And in order to avail yourself of statutory damages, you have to register that work within 3 months of first publication or before infringement begins. Otherwise, you have to prove actual damages. They're hard to prove. So often, the availability or not of statutory damages is going to make the difference as to whether you have the ability to assert an infringement claim or not, as a practical matter. And then, some of you have probably heard about copyright fair use. That's a term that comes up a lot. It's come up in the context of training of AI models, which we're going to touch on just a tad toward the end of my presentation. But the 4 factors to determine whether copyright, so use of someone else's copyrighted work, is fair are the purpose and character of the use. Primarily there, are you teaching in a classroom or are you using it for a commercial purpose? The nature of the work. So a compilation of data like a telephone book or some sort of directory would be low on the scale of originality, whereas not a documentary, but let's say a Marvel Comics film would be very high on the spectrum of originality. So that's the nature of the work. Amount and substantiality. Did you copy an entire television program or only the montage? Are you using only, a riff from a Rolling Stones song or the whole thing? And then the effect on the potential market. Because you took my newspaper article and posted it on your website, Now people aren't going behind my paywall to pay me for that same content. So that's the effect on the potential market. So courts weigh all of these factors in determining whether use is fair. And you may have heard about parity. So parity can be a type of fair use, but you better make sure it's parity. Yeah, it's got to meet those four use factors. Questions on copyright before we move on? Okay. Trade secrets. Of the 4 buckets of intellectual property, there's no registration process for trade secrets. They are protected solely by written agreements and restriction of access. Okay, so if it's a scientific formula, you restrict it to those scientists who have a need to know. If it's software code, you restrict it to the developers working on that program. Customer list, it's not, available throughout your organization. And trade secrets are protected federally and on a state level. There's a Federal Defend Trade Secrets Act. There's the Montana Uniform Trade Secrets Act. And I just wanted to share the definition with you here of a trade secret. So it's something that has economic value. So it may be a secret that my favorite color is blue. That has absolutely no economic value to anyone. It has to be something of economic value to your competitors. And then here, the subject of efforts that are reasonable to maintain its secrecy. So this means you must have written agreements in place with everyone, including your employees, right? There's not just confidentiality section in the employee handbook. You've got written IP agreements with confidentiality provisions with all of your employees. Zoot and other companies, but I did a visitor confidentiality agreement for Zoot at one point where everyone literally walking past their reception desk had to agree to that visitor confidentiality agreement right there. So that's really important to protect trade secrets, because when you go to litigate over them, I don't have a patent, I don't have a registered trademark, I don't have a registered copyright. There's no piece of paper from the government you can show the court to say it's a trade secret, right? You have to show them your written agreements and prove that you've restricted access. So any questions on trade secrets right now? Okay. All right. So I have a question here before we get into sort of the investor stuff. How many of you in the audience have been involved in IP due diligence, either from the standpoint of the target company or the potential purchaser? Okay, Eduardo has. Have you? And you. Okay. Someone from the investor or purchaser side? Anybody? Because I'm going to ask you a question. All right, so all 3 of you were from the target side. Okay, Eduardo, we've heard from you. Let's go to both of you. As the target, what was your greatest IP concern through that due diligence process? Ah. And so therefore we were working for IP directly. And so where the concern came in was the information that we obtained while we were creating the IP. So you are the bank, or are you? We are the software developer. Oh, you're the software developer. Ah, your customer. Got it. Okay. Ah, yes. Yes. And then, okay. And then they were going to be bought. And what was the particular issue, if you can tell us if it wasn't confidential? Generality. Yeah. That we were no longer part, because we were a consulting firm. Right. We were no longer part of that company. And that company sold what we had. Yes. Got it. Ah. Oh, you were involved in that whole process. Okay, got it. Good example. Good, excellent context. And you, sir, what was your IP issue?
Just exploring obtaining it now as somebody building that have IP protections available, and how to even go about learning, talking about them, while not divulging them. It's a whole new world to me.
I love it. Well, what's your business?
Indelible systems, building out photo invalidation infrastructure, ensuring that not generated or
Ah.
chain from capture through storage.
Ah, AI related. Okay. Yeah. Yes. AI prevention, maybe. Yeah. Anyway. In the digital space. Yep. So for you, you've been through the due diligence process. For you, you're thinking ahead, what do I need to know if I go through this due diligence process in the future? What should I be protecting? That kind of thing. Okay, to position yourself for sale or major capital infusion. Got it. Okay, so let's talk about what investors should look for then in terms of IP due diligence. So in the patent column, and I'm not thinking about time at all because I'm having fun, so someone will have to tell me when we're getting close. For patents, you want to know, are they live? They can expire after their natural term, or people can forget to pay maintenance fees. So are they live? Are they issued? A lot of clients will look at a number and call me and say, I'm concerned about this patent number 2024, well, that's a published application. And then if I look it up, maybe it was rejected and never issued. So does this target company or this client have live patents? What is the scope of that patent? So I'm going to move rather quickly through this, but we talked earlier about design patents. It's basically based on the drawings, narrowly construed. Utility, it's what do those claims say? Clients and people who don't sort of live in the patent world like I do will often maybe read the abstract because that's on the first page of a utility patent, or they just read the whole thing, or they look at the drawings. None of those things define the scope of the patent. It is solely the claims. And those claims can be narrower than what you just read in the written description and saw in the drawings. They can be narrower. They can also be broader. So both are allowed, so you have to review those claims. What is the scope of that patent? And then validity, we've talked a little bit about that, so I won't spend much time on that. Ownership, if there have been ownership changes along the way, make sure they've been recorded with the patent office. I'll say a little bit more about that when we get to trademarks. Enforcement, are there infringers out there? Are you going to be able to give an answer to the person who's preparing to write you a check for this IP portfolio as to why you have or have not gone after these infringers if they exist? So do you have a strategic enforcement plan? And then agreements, all right? So investors need to know, are there any patent license agreements? Are there settlement agreements? Are there coexistence agreements? Are there any kind of agreements out there that are going to affect this patent portfolio? All right, trademark side. This is a big one. Is it registered? I can't tell you how many times I see asset purchase agreements from general practitioners, and it just says, the buyer gets the trademarks and the goodwill, and they list the trademarks on a schedule, and they're not registered. And then I get it, and I get asked by the purchaser to go register it. There's a conflict. Maybe that registration is incontestable. We can no longer knock it out. So you want to look at whether those marks are registered, and they should be listed. I'm getting a little bit in the weeds here, but Darren and I work on a lot of these together, and we will list those registered trademarks in an exhibit to that asset purchase agreement. The scope of the trademarks. Your business may have grown since you registered your mark 10 or 12 years ago. We were selling, wheat flour, and now we're selling barley and, lentils and all sorts of other things. Have your trademark registrations kept up with your business? Okay, trademark law is use it or lose it. Contrast to patent law, you don't even have to be practicing. Most people are practicing the invention that they patented, but that's not a legal requirement. Trademark it is. So there are periodic renewals. And let's say a client registered their mark 4 years ago. Now it's going to be up for registration next year at that 5th year. And some marketing firm came in, I see this all the time, and changed a trademark. They changed it because they think the logo looks better this way, or they added another word to the mark. We're going to lose that registration because now I can't prove at renewal that you're still using that mark. So really important to have branding guidelines and be consistent with your use of those marks. Ownership. Okay, here's where I want to tell you a story without naming names or breaching confidentiality, but another Bozeman client, we thought this was going to queer the entire acquisition. The closing happened about a week ago. But what happened was corporate attorney in charge of this whole transaction, and I get pulled in. Can you just prepare the trademark assignments for post-closing? And I will tell you, this company that was being bought had no patents, no copyrights. It was all about the brand, okay, and inventory. They what they had in physical inventory. But their IP was all about the brand. And so I pull up each of these registrations. They are all over the place in the name of different companies. They weren't literally different companies. They were either predecessor companies or literally somebody got the name wrong. They said it was XYZ, but it was really XYB. So the ownership of those registered trademarks that you're acquiring has to match exactly the name of the selling entity in that asset purchase agreement, okay? So I said, well, the name of the seller in this APA, that seller cannot make the representation that it is the record owner of all these marks that you're buying. That was about, worth a significant chunk of the valuation in that transaction. So they close with a lot of caveats and money in escrow until I can clean up all those ownership issues. But I am gonna editorialize here. I was really disappointed that Sellers Counsel did not catch that and correct that before the transaction. It almost, like I say, derailed the whole transaction. Enforcement, another little bit of a story here. I have a client in the agricultural space. They named a product. Yeah, it was a type of lentil. And I want to share that with you because it is a food product. And you can imagine that people started referring to this particular ingredient then with the name that my client had come up with. And this is a small Montana company. They're in the agricultural space. They don't have a ton of money. They don't want to be paying me a lot of money to send a lot of cease and desist letters. That mark eventually became generic because they didn't enforce it. And so this is another situation where my client here was the company being acquired, but part of the asset purchase agreement was reps and warranties on behalf of my client that we were not aware of any infringers. I kept telling the buyer's counsel that we could not make that representation. So again, that deal closed, but it was probably, from my perspective, not Darren's, but it was the last sort of issue I had to deal with, was continuously going back to them saying, here's my IP enforcement spreadsheet. You can see who's out there, but we have not taken action. So that's another thing to think about. And then agreements. Again, you want to know, have there been coexistence agreements, consent agreements, license agreements? I will say this. A lot of trademark disputes or conflicts are settled with consent or coexistence agreements. There's a distinction between the two, but they're basically the same thing, right? Two companies agree, we're going to use the same or similar mark, but you're going to stay in your lane and we'll stay in our lane. Maybe we do online merch and you're just going to do brick and mortar because we both want to be able to register our marks and we think there's, our respective markets are not going to be affected. Those kinds of agreements are often worldwide, and they last forever. So if the company, it's part of due diligence, a big part of due diligence. I'm just going to say that, yeah, I better not say. Okay, let's move, yeah. Let's move on from this slide. So those are some of the things investors should look for in terms of patents and trademarks. Yeah, I think I can say this without naming names. It was a very famous Bozeman company that got acquired maybe 5 to 10 years ago, and they had a worldwide coexistence agreement. And I maintain with another company using the same name, but who used the name before my client had used this name. Different recreational space, but close enough that the trademark offices around the world, we kept getting, refusals because the trademark offices viewed this as close enough to cause confusion in the marketplace. I maintained a great relationship with the trademark lawyer for this other entity, and eventually he passed away, and I had a relationship, professional relationship with his wife. And anyway, long story short, because we maintained that cooperative relationship, they could come back to us and we would agree to a consent agreement in Japan, or, well, Japan doesn't accept consent agreements. It's called an assign and back, but you get my point. And then if we ran into a conflict in Australia, same thing. So those kind of things, consent agreements, really think about them. It's not boilerplate. It's something you're going to have to live with forever and will come up when you go to sell your company. All right, whoops. Will this allow me to go back? Yeah. So copyrights, we talked about it. It's a right without a remedy unless you're registered. Copyright notice. If you aren't including a copyright notice, which is that C in a circle, and then the year of first publication, and then the copyright owner on your works, it will limit what you can recover in damages. There's an innocent infringer part of the copyright statute that says if you're not using your copyright notice and the infringer had no idea it was registered, $200 for infringement. So make sure you're using those copyright notices. Ownership is a big, big, big issue. So I am going to pause here. Under the law, the employer automatically owns the copyright to everything your employees, I mean W-2 employees, do for you, okay, create for you within the scope of their employment. Not so with independent contractors. I spend a really good deal of my time cleaning up these messes, and they often come up at acquisition time. Or it's time you have a customer that wants to license a piece of software that you've been using internally, and you've paid an independent contractor to develop the software for you. And now the customer wants to license it from you, and you don't have ownership because you never got a written assignment from that contractor. So you do not own the copyright to things, including source code, any kind of software program that an independent contractor creates for you in the absence of a written agreement, okay? Even if you paid for it. And in the real world example, another Bozeman company that I'm thinking about, they paid this contractor for 14 years, and now she wants millions of dollars. Okay. Enforcement, similar issue we've talked about before. Agreements, joint authorship. All I'll say here is joint authorship is never a good idea because both authors have the right to commercialize the copyrighted work, but they have to account to each other. Joint authorship is just really messy. I would avoid it if you can. If you have a work of joint authorship, like a software program, then get those rights in writing so it's very clear down the road who has the right to what. Trade secrets, we've talked about. Agreements, restriction of access, and enforcement. So these are the issues that investors should be thinking about in terms of due diligence. Now, on to target companies. We'll go through this fairly quickly. Patents, so you want to look at, have the maintenance fees been paid? Is ownership updated? Because you don't want to find out that it hasn't been when you're about to close. Conduct a substantive evaluation of that patent portfolio. So claims, I'm going to really generalize here, but for utility patents, you can have system or apparatus claims or a device, right? So things. And then you can also have patent claims for methods. Method claims are ing clauses, right? Providing, processing, heating, mixing, okay? Method claims are doing type claims. Method claims are a lot harder to enforce than system claims. I'm just giving you an example of how you might conduct a substantive evaluation of a patent portfolio. So thinking of a Wyoming client of mine, he purchased a patent portfolio for $500,000 from an inventor in Michigan and just thought he was going to tie up the industry. And I counseled these guys beforehand. I said, look, all you've got is method claims here. Method claims are really hard because you have to prove that the accused infringer is doing every single one of those steps. If you said jumping forward and they're jumping sideways, I don't have infringement. And also, a lot of times, you don't have access to prove that they're infringing a method claim, right? If it has to do with a manufacturing process, you might not know exactly how they're undertaking that process unless you have access to the factory. Whereas with a thing, with an apparatus claim, I can get that thing, I can look at that thing, I can see if it has a bracket here or a manifold there. So that's an example of conducting a substantive evaluation of the patent portfolio. And then enforcement, we've talked about. So these are some of the same issues that investors will be looking at, but we're talking about them now from the perspective of the target company. And then trademarks, we talked about Section 15 affidavits. Make sure ownership is updated. Undertake a review of your trademark portfolio, and here there are several things you can look at. Have we registered all the marks that should be registered? Maybe we're now using a tagline that's really important to us. It's becoming prominent in our marketing, striving for a better way. That's DPS Electronics. You know, have we registered that? So consider marks, consider the goods and services. Maybe we registered your mark only for apparel when you were an online apparel store, but now you're getting into jewelry and bags and other things. Because what can happen is somebody else comes along and registers that mark for bags, and now, even though you're using it for bags, you never registered it for bags, so we've got to litigate to get our foot in the door there for bags, either defensively or proactively. And then territories. So I mentioned earlier, trademarks can be registered internationally. Are you in all of the relevant markets for your trademark registrations? And then enforcement, which we've talked about as well. Okay, target companies, thinking about copyrights. Review your registration strategy. So here's another example. I've had a client in Billings, this was a while ago now, but they were being acquired by Warren Buffett, and their product was, I'm just gonna say, a screw. Now, it was a unique screw, but it was basically just a screw. It was a thing you buy in a plastic, jug. And they had no IP protection whatsoever. Excuse me, you can't patent, well, we had protected their trademark, but you can't patent a screw. So they kind of called me in a bit of a panic, but I thought it was rather creative and said, we want you to register all of our technical drawings for our screws. So we did that. It was about 15 filings, but we did that pre-acquisition, and Warren Buffett was satisfied with that IP portfolio. So you can sometimes be creative. I mentioned earlier that there is a disclosure deadline for patents. So if you've been selling a product for more than a year, it's too late to patent it. But let's say you're looking ahead to an acquisition. If it's not functional, if it's ornamental or aesthetic, we could be looking at, for example, copyright protection. There's such a thing called trade dress, which I won't say a lot about right now, but trade dress is the shape of a product. I just want to illustrate to you, trade dress falls under trademark protection. You register it with the USPTO. But I want to illustrate to you that there are creative ways to think about protecting your intellectual property, even if you can't do that via a patent. Let's see. So you're going to want to review your copyright licenses. This is another due diligence issue. This comes up a lot with school districts that aren't necessarily targets of acquisition, but it comes up a lot in the school district realm and also in the private realm. But make sure you are compliant with your software licenses and any other licenses that you may have. But we see this issue most often in software, and that will be a rep and warranty in your asset purchase agreement. Are you compliant with all licenses? Disclose all licenses. They want to know about software licenses. And then enforcement. Is there anything we need to be doing to enforce our own copyrights? Trade secrets. All right, here, there's no registration process, right? As I said earlier, you can't provide that purchaser with a patent number, trademark, or copyright registration number. So with trade secrets, especially if you don't have those other forms of intellectual property, I see this often overlooked. Really think about it, identify an inventory, create a document that lists what your trade secrets are. It helps to think about that pre-acquisition. Document your security practices so it's obvious how you restricted access to those trade secrets. Review your agreements with your employees and your contractors, and your manufacturers, your distributors, anyone else who has access to that confidential information. Could be a partner, could be a vendor. Not everyone's going to have access to your trade secrets, but for those who do, make sure you have written either non-disclosure agreement or some other form of agreement with confidentiality clause. And then non-disclosure agreements, here just a note, I wanted to let you all know what I look for, because I probably review non-disclosure agreements or prepare them every single day. And I look for three things when clients send me one and say, should I sign this? I want to know, is there a requirement that confidential information be reduced to writing? I get why those clauses are often in there, but it's really when the other party wants to be able to use information that you disclose to them verbally. So I don't like to see that requirement. There's more general language that says, or any kind of information that under the circumstances ought to reasonably be treated as confidential. So I like to avoid that reduced to writing requirement. I've also seen it written elaborately to say, if the information is disclosed orally, you have to go back and reduce it to writing in a summary and provide it to the other side. That never happens. Term, there's a Montana state court case from a long time ago. I don't think many people are aware of it, but that said, at least under Montana law, there must be a term. Perpetual confidentiality agreements are not enforceable. I like to have a term. I've done anything from 1 year to 10 years. There should be 2 separate terms in any NDA. I know I'm getting into the weeds here, but we see a lot of NDAs. There's the contract term, but let's say your contract term is for 1 year. Let's say it's gonna expire December 31st, 2026, right? What if I disclose something to someone on it's gonna expire December 31st, 2026. And I disclose something to someone during the term of the agreement on December 30. I don't want it to be protected only for a day. So you also have to have that confidentiality clause that survives the expiration of the agreement. That's really important. And then injunctive relief is important also, because the default rule for breach of contract is you get monetary damages. So we always want to see a clause in the NDA that says we can get injunctive relief if you're out there spilling our secrets. I can go to court and try to get a temporary restraining order or preliminary injunction to tell you to stop. Okay, so these might sound like simple agreements. Not every agreement NDA you get from ChatGPT is going to have those 3 things. So look for those 3 things. Okay, questions so far, Darren? Good. I don't know if everyone heard that. Darren tries to tie the confidentiality term with the right to retain a copy of the other side's confidential information. That's a good point, Darren. Yeah. Any other questions so far? Yeah. Well, yes. Let's go to you first. I advise it. I advise it because of that one. Well, there's 2 reasons. Because of that one long ago case in Montana. But there's another reason. I'm glad you brought it up. Because when you go through the due diligence process, they're going to ask you for basically all unexecuted, meaning it's still live agreement, right? If I terminated an agreement last year or 5 years ago with written notice of termination or it expired, there was no automatic renewal. There was no renewal. It just said 5-year term and it's over. I don't have to disclose that contract or list it. But if you have an NDA with some company you dealt with 10 years ago and it's perpetual term, there was no term, you have to disclose it. I do not advise perpetual NDAs, yeah. Darren, and then we'll go back to you, yeah. Yeah. And we include that language in our, yeah, which is going to complicate our discussion here today. But yeah, as a general rule, yes. Okay, so I have 2 questions for you, because your question said if you already have patents, do you have utility patents or design patents? Utility, and are we talking about software? What are we talking about? Well, you can't patent biology, so what do you mean, like a therapeutic? Genomics, okay, okay. So I can't copyright a gene sequence. So there would have to be something that's original, that was created by a human in order for me to register it with the Copyright Office. That's why I asked if it's software, if you have software, if you're delivering genomics through a software program, yes, I can register the code with the Copyright Office, and I might have a utility patent on that. So yes, I would advise both. And I'm happy to answer your question in greater detail confidentially if you'd like afterwards too. There is an incompatibility, and this is another Montana story, between 2 types of intellectual property. So I really appreciate your question. You cannot, I mentioned trade dress. Trade dress is, and everything I'm going to tell you is a matter of public record if you cared to look at the Trademark Trial and Appeal Board, so not divulging anything confidential. But trade dress is the way something looks. So anybody familiar with Proof Research? They make rifle barrels in Columbia Falls. Yay, right? They're awesome. Okay. So they're carbon fiber wrapped barrels. Prior counsel filed a utility patent application and obtained a trade dress registration for that look on the barrel. Okay, it's a pretty cool look. People see it on the shelf wherever, and it's very recognizable. We attempted to enforce the trade dress. I came in then as litigation counsel. We attempted to enforce that trade dress, and we lost because of the pending utility patent. So those 2 forms of intellectual property are incompatible, and I haven't told you why yet. The reason is trade dress, like copyright, is not supposed to protect anything functional. So basically the Trademark Trial and Appeal Board said you can't have your cake and eat it too. Either it's functional and you're getting your utility patent to that carbon fiber wrap barrel and the 7 laminated layers and how you do it, or you're going to get trade dress protection. Now, our argument was the trade dress is only protecting, it's not protecting those 7 underlying layers, and again, this is all public information, it's in a patent now, and how we wrap them and at what angle. That trade dress is just protecting the end result, what it looked like. But so you can encounter situations in which two different types of intellectual property are incompatible. Did I miss anyone with a question so far? Wrap it up already? No way. Okay, AI. So the USPTO, I've got 20 seconds, I'll go really fast. Might go over by 1 minute or two. USPTO issued AI inventorship guidance in 2024. Basically, a patent can be granted if there's a significant human contribution. It's not enough to merely enter prompts into an AI model. It might be enough if you're modifying those AI-generated outputs, or if you can show that you're making inventive decisions. And you really have to make that case now in patent applications involving AI. A lot of the calls I'm getting now on patents involve AI. This is trademark. How has AI affected trademarks? It's generating logos. It's coming up with names. Long story short here, in the trademark realm, it's not who comes up with the logo or the name, it's who uses it in commerce. So AI isn't having a huge impact in the trademark realm. Copyright law, again, the work must be created by a human. Can't use Canvas, generate an image, and then register it with the Copyright Office. All right, so here are the key takeaways, and this will be my last point. US patent law requires a human inventor. Copyright law, human authorship. Trademark law, not affected in principle, but will face new enforcement challenges. I breezed over that part, but I'm spending a ton of time in my office now battling AI-generated copycat websites and Facebook images. Okay, one note about this. AI training data lawsuits. I said here may shape copyright law for decades. Anybody know what I'm talking about? New York Times versus OpenAI. Okay, so that has to do with the use of copyrighted information to train these models. Just be aware, when those models spit out outputs, that output might infringe a copyright. OpenAI is not giving you a guarantee that it doesn't. And then Congress, the courts, USPTO, and Copyright Office actively developing new AI-related policies. Thank you for your attention.